This video is for educational purposes only and is not legal advice.
We are rapidly entering the era of algorithmic contracting. Digital assistants are now capable of negotiating, forming, and executing commercial agreements autonomously at massive scale. This creates a legal void. When an algorithm makes a critical error or hallucinates, generating false outputs not grounded in its training data or reality, someone has to be held responsible for the resulting contract. The first major framework to address this issue comes from the United Nations Commission on International Trade Law, or UNCITRAL. In 2024, they adopted the Model Law on Automated Contracting, known as the MLAC. The MLAC is designed for business-to-business, or B2B, transactions. It assumes highly sophisticated parties and maximizes their freedom to design and deploy automated systems with minimal interference. But individual shoppers require a completely different architecture. The European Law Institute drafted the DACC, the Model Rules on Digital Assistance for Consumer Contracts, specifically to handle business-to-consumer, or B2C, relationships. To shield individuals from autonomous errors, the DACC forces a structural shift. Instead of relying solely on lawsuits filed after a bad deal goes through, known as ex post liability, it mandates ex ante protections, requiring safety rules to be hard-coded into the software itself before it ever reaches the market. The DACC starts by establishing the baseline legal status of the software. A digital assistant is not an independent actor or a legal agent. It is strictly a tool wielded by a human principal. Because it operates as a tool, the framework splits the legal reality of using an AI into two distinct contracts. The first is the supply contract. This agreement exists solely between the individual consumer and the software developer, providing the digital assistant application. The second is the algorithmic contract. This is the actual transaction executed autonomously by the digital assistant with an outside business. If the tool buys the wrong flight, the software developer is not a party to that second contract. They hold zero contractual liability for the agreement made with the airline. Since consumers cannot sue the software developer over a bad purchase made by the AI, the DACC has to build the protection into the tool itself through strict structural software regulation. Chapter 2 of the DACC imposes strict code-level design requirements. Any digital assistant intended for consumer use must meet specific interface benchmarks before it can be legally supplied. This diverges sharply from the UNCITRAL MLAC, which gives businesses open-party autonomy to design automated systems however they see fit. Article 6 of the DACC limits the speed of machine execution. Digital assistants must be programmed with built-in user interface friction to prevent runaway automated purchasing. Developers are required to offer at least two types of friction. The first is the confirmation model. This configuration forces the software to halt its process and require an explicit, manual human approval input before an order is placed. The alternative is the objection model. This method introduces a mandatory time delay window. It gives the consumer a set period to intervene and cancel an automated action before the system finalizes the transaction. Under this framework, consumer protection is a functional constraint, hard-coded directly into the product's interface. Algorithms process information and execute commands at speeds humans cannot match. If an AI operates in the dark, it can overwhelm counterparties before they realize they are dealing with a machine. Take the context surrounding cases like Moffat v. Air Canada. An electronic agent designed to find cheap flights might scrape airline servers thousands of times a minute, violating terms of service meant for human visitors. Under Articles 8 and 19 of the DACC, a digital assistant must technically disclose its algorithmic nature to the counterparty. It must also declare that it is acting on behalf of a consumer. This mandate works in reverse as well. If an individual unknowingly negotiates with a corporate chatbot that fails to disclose its artificial nature, the consumer gains the legal right to cancel the contract entirely. The rules provide one clear exception. Disclosure is waived if the automated nature of the transaction is obvious to a reasonable person, such as an e-commerce website instantly emailing a receipt. By forcing systems to identify themselves, the rules rebalance the information asymmetry, ensuring humans know they are competing with machine processing capabilities. The central pillar of algorithmic contracting is attribution. Article 22 states that if you deploy a digital assistant, its actions are legally attributed to you. You assume the risk of the tool you chose to use. Adaptive machine learning systems evolve. If an algorithm learns a new behavior and makes an unpredictable error, the legal question is whether the human still bears the cost. We see this tension in the landmark case Quine v. B2C2. Two algorithmic trading servers interacted without human oversight, and a system glitch resulted in a series of trades at heavily distorted prices, generating massive financial liability. Reviewing the case, Lord Mance offered a dissenting view. He argued that while anyone using a computer assumes general operational risks, they do not assume the risk of a fundamental breakdown in the machine's normal logic. This chart shows how the DACC formalizes this logic with the Article 22(2) reasonable expectations ceiling. If a digital assistant's actions drastically deviate from what the consumer could reasonably expect based on the software's parameters, the resulting contract is stripped of legal effect. If an AI relies on a weather API that glitches and reports a temperature of 400 degrees, prompting the assistant to autonomously order 400 bags of ice, that severe deviation severs the attribution. The contract is voided. Compare that to the business-to-business rules in MLAC Article 7, where an unexpected outcome is explicitly noted as an invalid excuse to deny legal attribution. The DACC establishes a firm boundary. Corporations cannot legally enforce and profit from the severe hallucinations of a consumer's algorithmic tool. The architecture of the DACC creates a sequential defense. It begins with strict design constraints on the software, requiring built-in friction, and flows into mandatory technical disclosures during the transaction. From there, it enforces strict attribution for the machine's actions, but caps that liability with the safety valve of reasonable expectation. These rules operate as an interlocking system designed to guarantee that human users maintain ultimate legal agency over autonomous systems. While the UNCITRAL MLAC preserves the autonomy required for global corporate trade, the DACC proves that consumer safety against algorithmic speed requires active, structural legal engineering. As commerce hands execution to AI, the rules governing trade can no longer exist purely on paper. They must be written directly into the codebase.
Thank you for watching.